Okay, hello.
This meeting is being recorded.
Hello and welcome to everyone. Thank you for joining us at this SARE webinar today, where Michelle Leger and I will be presenting some work investigating the overlaps between a number of different pieces of legislation that deal with online content. Joining us today for this discussion are Irene Roche Laguna, who is Deputy Head of the Digital Services unit at DG Connect of the European Commission, so representing policymakers. We also have Matt Allison, who's a Senior Public Policy Manager of Vodafone Group, Owen Bennett, International Online Safety Principal at Ofcom, which is the UK communications regulator, and Zoe Pellegrini, who is EU Policy Officer at Mediaset, one of the large broadcasters we have in Europe. So we, as usual for a SARE event, we have a mix of industry representatives, policymakers, and regulators, and we also hope we get to hear from you in comments and questions. So we will start by presenting the work, and then we will be hearing from our speakers and then opening up for questions and discussion. So Conrad, if we can start with the slides. So what we will be presenting today is a very specific comparison that examines the services in scope and the harms in scope. Next slide. As I said, we will be covering these three areas, but also something that emerged in this when we were looking at scope and the interpretation of harms was a special treatment in some cases in relation to journalistic content. So we'll be talking about that. You can see here we looked at three pieces of legislation. When we started, the Digital Services Act was not yet adopted, but it has been since. And so what you see does reflect the final version of the DSA, the AVMSD, which was revised in 2018, the Online Terrorist Content Regulation, and those first three pieces are all EU level legislation. We also looked at the draft online safety bill, which is from the UK. And this was very interesting to us because it was a comprehensive piece of legislation. However, this is not yet adopted. So we are still working on the draft that was proposed, but this is still in the UK Parliament and up for amendment. Next slide. So I will hand over now to Michelle from University of Namur and also one of our SARE research fellows, and she will guide you first through the discussion about services.
Yeah, so thanks Sally, and hello to everybody. Yeah, so I mean the objective was to really compare two aspects very specifically. So the services in scope of all these pieces of legislation, but also the harms in scope, and that's what Sally's going to talk about. So I'm going to talk about the services in scope. So I mean, you may think, well, you know, why are we doing this? Well, it's really, you know, to have a comparative view and to see, you know, what the best practices may be, to see where there are overlaps, what's common features, but also the differences. And of course, the differences are very interesting because it means that, you know, operators have got to comply with all these pieces of legislations, and the services in scope would obviously be different. And so we thought it was interesting to compare the services in scope. So when you look at it from a general, very macro point of view, you can see here we've represented the various scopes of application, if you want, of the pieces of legislation in these circles. And I mean, the widest piece of legislation that we've got at the moment is certainly the Digital Services Act, because it covers a subset of information society services, which are the intermediary services, and they include the caching, the mere conduit, so the technical internet layer, but also the hosting service providers, hosting services, the online platforms, the very large online platforms, and the search engines. So it's really quite wide. And then you've got the Online Safety Bill, which is the sort of equivalent in the UK of the DSA. And here you can see that it's also very wide, but it doesn't cover the internet layer, if you want, the caching and the mere conduit, but it covers a very broad category of user-to-user services. Search is also included, and what's specific here is that we've also got in the bill the idea to cover publishers of pornographic content, so very specific type of service, which is not really intermediaries because they're actually publishing the content. And then we turn back here to the EU legislation and the terrorist content regulation, that's got a more narrow scope of application in the sense that it only covers the online platforms, which are defined as the hosting service providers that disseminate content to the public. So they're a big core of services, of course, but not as wide, certainly, as the DSA. And then you've got, to make things even a little bit more complex, you've got the video sharing platforms, which only cover platforms that provide user-generated content in the form of video or programs. So we're only talking about audiovisual content there. So you can see that from that very first slide, that the scope of application is already quite different. And then if you turn to the next slide, Conrad, what we've done is we've taken a number of services and we've then gone into more detail, with there's lots, for those that like definitions, a lot of definitions in the report. And we've tried to map out the coverage of some of these important services. So as we've already mentioned, the technical internet services, well, the DSA does stand out because it's the only one that really does cover them explicitly. And also there are historical, there are reasons why they are covered. It's because the liability provisions of the e-commerce directive have been introduced into the DSA. So naturally they are covered, but they are also covered in other, other provisions also apply to these technical internet services. We note that some of them grey zones that existed under the previous directive are still there. Some of the services is not entirely clear. It depends on the technical functionality if they're going to be covered or not. So we list some of those. And then you can see AVMSD, TEREG, and OSB certainly don't cover those technical internet services. Search, that was one that evolved quite substantially during the course of adoption, of course, of the DSA. Some may remember that it wasn't really mentioned in the initial drafts, but then it was certainly covered. The very large online search engines are certainly covered, but again, it's not entirely clear if they fall under the category of caching or of hosting services. It has a few consequences, of course, because we have a tiered approach in the DSA, and not all the obligations apply to the caching services that apply to the hosting service providers. And then certainly not covered under the AVMSD. Covered certainly under the Online Safety Bill, so there we've got the same situation as under the DSA, and under the Terrorist Content Regulation, again the same grey zone exists as under the DSA, but if they're considered as caching services, then in our view, they'll be out of scope of the Terrorist Content Regulation. So that's quite interesting as well. Pure online storage, again, covered certainly under the DSA, but not under the AVMSD or the TEREG to the extent that they're not providing services to the public in general. Under the OSB, we note a certain amount of grey zone here because probably the online storage for use by companies is exempted and not covered under the OSB. Presumably, therefore, the others are. Online marketplaces, yes, covered everywhere except under the Audiovisual Media Services Directive. What's specific with the DSA is that we've got very special rules that also apply to the online marketplaces. Online gaming, that was something we were looking for in all the pieces of legislation. They're not mentioned. whereas, we feel that that was a bit, everybody's talking about them, of course, so it's always a bit difficult to categorize online platforms. Online gaming, probably they would fall under the scope of these pieces of legislation, but you'd have to look at the definitions precisely to see that. Porn publishers, as I've mentioned, is only covered under online safety bill. And live streaming, yes, covered, but no specific rules. Anyway, all that's in the report, so you can go and look and see our analysis in relation to these different types of services. So maybe, Conrad, the next slide, and that's going to be my last slide on the services in scope. We're really trying to bring you here the sort of key findings of the report. We're not going to have more general conclusions. These are really the findings of the report. In terms of all the initiatives obviously seek to capture the non-established providers as well, to the extent that they're providing services in the territory in question. We've looked at all the mechanisms that are used, and they're relatively aligned, except maybe on the rules on VSPs in the AVMSD, which does require some sort of connection with a physical company that's established in the EU, whereas the other pieces of legislation don't at all require that anymore. And you need just to appoint a legal representative if you fall within the scope of the law. So it does show you as well that all these companies will actually need to comply with all these pieces of legislation, which is interesting. What we've seen is that none of the EU level initiatives cover a procedure to designate the services in scope, except for the VLOPs and the VLOSes, which are going to be designated by the European Commission, and we'll all know who they are because the names will be published in the official journal, so that's simple. And there's quite an interesting contrast there with the online safety bill, because there is a procedure whereby Ofcoms will have to publish a register of the services in scope and say and with detail under which category they actually fall. So that was something that we thought was interesting. Also, the DSA, and well, let's put it positively, the AVMSD contains an interesting mechanism to solve conflicts of jurisdiction between the member states in terms of who is it that's going to be responsible for supervising particular services. Of course, no, we're not talking about the VLOPs and the VLOSes, where the Commission will be primarily responsible. And so there's an interesting mechanism under the AVMSD there, where the European Commission can actually step in and solve a dispute on jurisdiction. The DSA and the TEREG, well, more importantly, probably the DSA doesn't contain such a mechanism. So it'll be interesting to see, how conflicts of jurisdictions could be solved. And you can think of just say Mastodon that we didn't mention at all in the report, but this is something that with decentralized servers everywhere, you can imagine that there could be a conflict of jurisdiction in the member states about who would be competent to oversee a service like that. So I'm not quite sure how that could be settled. Also, I mean, some of these grey zones that exist under the DSA, it'd be interesting to see, how basically future-proof these pieces of legislation are going to be. We haven't made an assessment about, one will be better than the other because we don't yet see a mechanism particularly, except maybe under the OSB, where Ofcom has got more power. Under the DSA, it being a regulation, it's a bit more difficult to understand who's going to settle these questions. But so that's in a nutshell the findings that we made on the services in scope. So maybe now, Conrad, you continue on, and then we'll take questions. As Sally said, if you have them coming now already, you can send them in the chat as well.
Mm-hmm. Yes, if you have questions about services in scope, don't wait to hear the end. Go ahead and put them in, and we'll keep track of them. You can put your questions in the chat. So if anything, if you have any questions about scope, and we'll be dealing with them in a little while. So I'm going to just present the key findings in relation to the harms in scope. And of course, there is more detail on this in the report itself. I'm first dealing with illegal harms, and then I'll deal with the legal harms, because there was quite a difference already at the level of illegal harms. The DSA was, of course, the broadest, and it covers all content that is illegal by EU and member state law, as long as that member state law is not in contradiction with EU law. And this has potential to be vast, to say the least. And we also thought that it also has a potential to raise some problems, because it doesn't really spell out who gets to decide whether or not that member state law is in contradiction to EU law or not, and what happens in the meantime. So assuming that, you know, if there is a conflict, it's heading toward the Court of Justice to decide whether or not the member state law is in conflict. What happens in the meantime? Does the platform decide for itself, or is there going to be regulator involvement in that? So that is one issue that this kind of raised for us in terms of implementation. AVMSD and TREG clearly cover a very specific illegal harms related to content, and you can see here what those are in the figure on the side. But though they are specific purposes, they are protecting from illegal content that is illegal at the EU level, so incitement to hatred, terrorist content, and the Online Safety Bill is an example of a national level law, right? So it's actually doing the job of creating some new criminal offenses. And these have been created based on not the characteristic of the content, but the intention and the effect of the harm caused. So so the criminality is not linked to whether or not the content itself represents something that is illegal, but whether or not the intention and the effect of the harm is illegal. So these are new offenses. There are some hierarchies. Now, the DSA doesn't very overtly establish hierarchies. It does talk about manifestly illegal content, and it basically gives presents an expectation that will be handled in a certain way by the platforms. The OSB, the UK draft law, has a clear distinction between priority illegal content and regular illegal content. And the priority illegal content is defined very directly to specific criminal offenses that appear in other existing legislation, or the new criminal offenses that are created within that law itself. Now, the DSA hierarchy, the sort of the EU hierarchy, can kind of be seen when you put together the DSA and the AVMSD and the TREG, and of course the soon to be debated and probably adopted laws related to child sexual exploitation material. So kind of at the EU level, we do have a bit of a hierarchy in that there are specific laws to deal with what would probably be considered manifestly illegal content, as well as the overarching DSA. And in the OSB, we have this example of national level law setting out the priorities. So it isn't just that illegal is illegal, there's more illegal and less illegal, or primarily the kind of illegal that these are really aimed at in terms of preventing harms to users and society. So Conrad, can we go to the next one? Interestingly, I'm going to move into the idea of legal harm, right? And now these tend to be ones that relate to, you know, content or behavior that would, you know, generally be legal, doesn't amount to any kind of criminal offense, but that could still be harmful. And only the Online Safety Bill in the UK actually contains a direct definition of harm. But this definition is rather narrow. It individual harm, harm to individual users, that is psychological or physical harm, but it is connected to individual users. And this is very different from the approach of the Digital Services Act, which covers wide societal and collective harms in relation to very large online platforms and very large online search engines in particular. So if we look at the things that very large online platforms and very large online search engines have to do risk assessments on, these are very broad harms that recognize that there can be harms to public processes and public institutions such as elections, right, and civic discourse. They recognize the collective element of this. And so while all of these bills or pieces of legislation recognize relevant risks to freedom of expression, they do so in a way that is about balancing the freedom of expression with the protection from harm from content aims. Whereas the DSA has an approach to risks to fundamental rights, including things like media pluralism and freedom of expression, which is much broader and in our view would imply that there's a potential there for the DSA to also be about positive intervention. So if you think about maybe, you know, the risks to media pluralism, and an intervention to mitigate those risks might involve support for content creation. It might involve enabling or establishing spaces for minorities in order to be able to have civic discourse or to engage in content creation. So there might be positive obligations that come out of those kinds of risk assessments in terms of mitigating the risks to these more collective and public harms. I think we can go to the next slide. We have an aim to prevent harm to minors, very clear concern in AVMSD and the DSA and the OSB, particularly the AVMSD and the OSB. And this is, it's still very much an individual approach in the AVMSD and the Online Safety Bill. This is about preventing exposure to certain content that might harm them mentally, physically, and morally. Whereas the DSA explicitly also says prevention of risks to the rights of the child. And if you look at the interpretations of the rights of the child coming out of the UN, it's clear that the rights of the child are also not just about preventing them from harm, but also about enabling them to operationalize their other rights. Commercial communication, it was a key element of the AVMSD. It always has been part of that piece of sectoral legislation, but it's also treated in the Digital Services Act. Here we have transparency of sources of advertising. There is consideration for the wider risks that might be posed from advertising systems. And the Online Safety Bill doesn't really deal very much with commercial communication, but does address fraudulent ads. And something else that we found cutting across these pieces of legislation was we decided to call it well-being category related to harms, but there is a clear effort to prevent harm from mental and physical health of individuals in the Online Safety Bill. And this is also reflected in the commercial communication standards in the Audiovisual Media Services Directive, which some of which have been there for a while, say, for instance, in relation to tobacco advertising or advertising of alcohol. But now we also have ones related to unhealthy foods, ones that are high in fat and sugar, etc. And the DSA takes a public health perspective, including gender-based violence and broad idea about public health. So we see these instruments being used to attack possible harm to people and societal well-being. And I think we will move on now to the short discussion of the journalistic exceptions before we open it up to our speakers.
Yes, thank you, Sally. So the last bit we didn't know where it fitted quite, but anyway, this is it. Journalistic and media exceptions. So we've looked at it from, well, we've covered two aspects. There's first of all the prominence option, which is to make sure that the journalistic content, audiovisual content is prominently displayed on platforms somehow. And then you can look at it from a special derogation option from ordinary content moderation, if you want. And we see that, I mean, there's a lot, in all the pieces of legislation, we've got something. It's a little bit different in each of them, though. Under the Audiovisual Media Services Directive, we've got a rule that allows but doesn't oblige the member states to make sure that there's appropriate prominence of audiovisual services of general interest. But it leaves a lot to the member states to decide, you know, what is an audiovisual service of general interest, what are the platforms that are concerned by this, and also member states don't necessarily need to introduce a prominence requirement. The terrorist content regulation basically says it doesn't, the whole of the regulation doesn't apply to certain categories of material that could contain terrorist content, I suppose, like journalistic content or like content that's uploaded for educational purposes. So there's a sort of complete carve out, if you want, from the scope of the TEREG of certain types of content, including journalistic content, okay? And then in the DSA, there were attempts to include, you know, a proper derogation, if you want. And in fact, it didn't make it in the final versions of the text. There are rules to say that all the intermediaries in scope, so we're not talking about here just the very large online platforms, need to apply their terms and conditions with due regards to the rights and interests of the parties, including pluralism of the media. So there's an idea there that you have to be specifically careful when you're moderating content that's linked to the media. And there's this idea of risk assessments, the VLOPs and the very large online search engines need to carry out. And two of the categories of risks that they need to examine do relate to public interest content. So there's an idea that in the risk assessments, they need to capture somehow that sort of content. So if you turn to the next slide, Conrad, the OSB does include a special rules for news publishers and audiovisual media services, and they in fact are sort of shielded from any idea that they could be committing specific communication offences. So if you want, the communications offences don't apply to them. And it also requires here, it's the large one, so it's you know, the equivalence to the VLOPs services to have special systems and processes in place, you know, to ensure the importance of content of democratic importance and journalistic content. So all that still needs to be decided completely, because this is a controversial area. And then, of course, now you probably all know that the proposed European Media Freedom Act also includes now special provisions on content coming from media services that would be applicable to the very large online platforms, but not the search engines. So, I mean, all this shows you that it's a hugely controversial area. We can probably all agree to that. That it's really quite difficult and key to define which is the content that can benefit from the special treatment. That's a difficult one. What is this special treatment, and what is the role for regulators in all this, in applying these rules? So it's a complex area. We don't have any specific recommendations, I would say, in the report. We just wanted to flag the differences of approach.
Okay.
So
Okay.
I think, yeah, that puts an end to the linear presentation, doesn't it, Sally?
Yes, thank you very much, Michelle. So you can get into more of the details in the actual report, which is available already online. We already have one question coming in, so I have seen that. But first, we're going to turn to our invited speakers to react sort of briefly to the report. They will have seen it already. So I will ask first, Irene, if you can join in.
Yeah, thank you very much, and good afternoon, everyone. And thank you very much for this report, because it's very interesting to see the comparison of the DSA, the tool that I have helped negotiating, and other instruments, having in mind that they are not always easily comparable. It is interesting that you show the DSA as a self-standing instrument in isolation compared to the AVMSD, to the TERREG, the Terrorist Content Regulation, or the UK's initiative. But on the other hand, for us, the DSA should not be seen in isolation. The DSA is the framework, it's a horizontal instrument, and then it has to be complemented or seen in consistency with sector-specific instruments. So you are checking, comparing the horizontal instrument with two particular sector-specific instruments. Just coming back to the history, in 2016, the Commission, in the communication on online platforms, I think, we decided not to legislate on horizontal issues regarding notice and action procedures, which was then very high on the agenda, and the Germans afterwards legislated on the NetzDG, etc. But we said we will take a sector-specific approach. And it was because of that that we have now the Copyright Directive, the AVMSD, and the Terrorist Content Regulation. So these were three specific sectors that already at that time were showing tensions, and it was decided to move forward. But again, these are not the only ones. There are also other instruments that have been adopted since, like the Market Surveillance Regulation for product safety. Now the General Product Safety Regulation is being negotiated. You have mentioned the EMFA, the Media Freedom Act, the short-term rental regulation for a very specific issue. So this shows that the DSA should not be checked in isolation, but to be seen whether the problem is horizontal or the problem is vertical. And that will allow to see whether the DSA serves its purpose or not. This is a bit what I wanted to mention in terms of the historical perspective and the need to have a more holistic comparison. Obviously, the proposal, the OSB proposal from the UK is very interesting for us, but it is not the only proposal that it's on the table from a third country. So we are also checking what is happening in the US, what is happening in Australia, and this also would complement this overview. Then the other element that complements the DSA and makes it more flexible, because in your study you mentioned, well, the OSB is flexible because it allows the regulator to issue codes of practice. The DSA can also be complemented via codes of conduct. There is Article 45, Article 46, allowing precisely to move on in that direction. And we already have sector-specific codes of conduct or codes of practice that have the intention to become to get this stamp of a DSA code of conduct, such as the code of practice on disinformation, the code of conduct on hate speech, the counterfeit memorandum of understanding, etc., etc. So this will also allow the DSA to be adapted and flexible in this sense. My last point is that I think that the study indeed compares the instruments, so checking what covers the one, what does not the other cover, but it does not go down to the tricky question, which is what will apply when? Because that is when will the DSA apply when it is a video sharing platform, or will be the AVMSD? If it's terrorist content, should apply only the terrorist content regulation, the DSA will apply. So this has a lot of details and nuances that I would be happy to hear your views about. But I will stop here, as I was given 5 minutes, and I will be happy to come back in the questions and answers.
Okay, thank you, Irene. We were going to turn now to Matt Allison from Vodafone for some comments. I think Irene has raised some very interesting questions here. Yes, and we would love to be able to tackle this tricky issue of what will apply when. And SER does have an institutional design report that was published as well. So we didn't get very much into the institutional design issues, but we were, hoping that this could inform some discussions about what should apply when. But now over to Matt, and then we will.
Thank you, Sally, and thank you both Sally and Michelle for the report, which is really interesting and helpful from our perspective in grappling with ultimately the enforcement and the implementation of these different regulations, and approaching this as a service provider clearly active both in the EU but also in the UK. It's vital to unpack the definitions, the scope of these regulation, and two particularly important aspects of this report in that context, comparing, of course, the service providers which are going to be included, and looking at what we call the passive intermediary layer of service providers that really provide the infrastructure that underpins communications and network technology, but also the harms that are in scope, and the contrast that we have there between sort of harmful content, legal but harmful content, public harms, private harms, etc. These are all issues that we'll need to unpack. I normally start in these discussions just by outlining very quickly Vodafone's stake in the discussion, so that that's obvious and upfront to everyone. First of all, of course, we're an internet service provider, so we do bear the regulatory obligations as a mere conduit under the DSA and its preceding regulatory framework under the e-commerce directive. We also do have a small portfolio of primarily enterprise-focused cloud services, so we do keep an eye on the obligations for hosting service providers. But I would say perhaps the bigger, the wider context of Vodafone is to ensure that we have a safe internet for our customers, which is ultimately beneficial for our service. They don't ensure that they don't encounter too much illegal or harmful content. But secondly, also as a victim actually of misinformation and targeted conspiracy theories around, for example, the impact of 5G communication technologies. So we're highly motivated to ensure that we puncture the bubble, if you like, of false and misleading information online. So that's been really our stake in the discussion. And Irene, I like that you take quite a historical perspective to this question of platform regulation and dealing with illegal and harmful content online, because it is indeed a multi-year effort. And I thought I would just use my remarks to maybe highlight some of the key advantages, the wins, if you like, under the DSA, and some open questions and things that perhaps weren't sufficiently addressed as we sort of look now forward to the implementation phase. So yeah, with the DSA, from our perspective, welcome, of course, that we essentially confirm some of the foundational principles of the liability regime for online intermediaries, and that we clarify, for example, that the country of origin principle applies, and even go further and stipulate, for example, the actions that service providers can take within the confines of the law to deal with illegal and harmful content. So we have the introduction of a Good Samaritan principle now under the DSA. But for us, really, the key is moving beyond clarifying and updating the liability regime for the broad set of intermediaries and applying on top of that an additional targeted set of obligations that would apply to a subset of intermediaries who are, if you like, most responsible for the dissemination of illegal and harmful material online. And in that sense, moving from that overt focus on after the fact liability and putting in place upfront rules based on responsibility and essentially the design of services, which, as I say, contribute most significantly to the sharing of illegal and harmful material online. So in that sense, we're very supportive of introducing a new definition of online platforms under the DSA. And when we're talking about definitions, one really relevant aspect that I'd like to introduce to this discussion, which actually has its foundations in the terrorist content regulation, is the notion of a service disseminating material to the public, and that being a key criteria which says you go beyond the obligations that would apply for traditional hosting services, and you have a new set of obligations that would apply for those services which disseminate material to the public. That is a principle that we are very much in favor of. And then going beyond that, for services that cross a certain size threshold, again, the obligations and the regulation, kind of by necessity ratchets up for those bigger service providers. So, in a nutshell, that's really, the principles of the DSA that we endorse. Looking towards implementation and enforcement, there are a number of open questions that we're watching. One that I would raise actually is that whilst in principle the DSA would tend to, from our perspective, ultimately reduce the reliance on serving blocking injunctions at the network level to ISPs and increase targeted action taken closer to the content uploaded by the user. In practice, what we've seen is the opposite, actually. And even since the DSA was agreed upon, an increased reliance on blocking injunctions served at the network level, particularly in the context of the Russia sanctions package, where we are having to enforce a complex patchwork of essentially blocking injunctions across the EU, which does present challenges, and that is something that we do ultimately want to get away from. And the second is the potential for, while we have this nice, neat horizontal framework under the DSA, renewed and kind of reinvigorated efforts to deal with content regulation in sort of vertical slices, where you're introducing notice and takedown provisions that would go beyond or diverge from the horizontal rules that you have under the DSA. And two that I would flag there as being relevant are, of course, the approach to child sexual abuse material that we have very live discussion under the regulation there, but also anti-piracy efforts where there are ongoing pushes, as we've seen, to have more aggressive content takedown approaches within regulation, which from our perspective could diverge in an unhelpful way from the horizontal measures that we have under the DSA. And then maybe just to hand over the discussion, you posed the question, well, how future-proof are both of these regulatory frameworks? I was at a very, very interesting session hosted in London a couple of weeks ago, looking at the metaverse and assessing the potential for the regulatory frameworks that we have to deal with those challenges. Actually, one of the conclusions was that the definitions in the online safety bill are potentially broader than those that are used under the DSA to accommodate for technologies like the metaverse. But really an open question for the rest of the panelists, and happy to provide my own reflections on this, is having undergone this mammoth effort to have a horizontal framework for online platform regulation, do we need to do it again already, or is it possible to add in kind of new definitions, new clarifications using, for example, implementing acts at the Commission's disposal, so that we don't need to completely reopen the process? That's something that we'll certainly be watching with interest. Thank you.
Okay. Thank you very much, Matt. It did take us a very long time to reopen the e-commerce directive discussion in the end that got us to the DSA, didn't it? Okay, so now we are going to turn to the national context. And Owen Bennett from Ofcom, if you could pop in from the perspective of a regulator and from the UK. Thank you.
Thank you, Sally. And maybe to begin, I can just echo Irena and Matt, and thank you both, Michelle and Sally, for this report. So I've already had the chance to read it, and this slide deck has also been very helpful, just in the sense that it gives a very, very clear and kind of comprehensive breakdown of the various divergences and overlaps. And obviously, from my point of view, I'm particularly interested in the relation of the OSB in the UK to the various EU initiatives. So it gives quite a helpful overview, and it's something that we're acutely aware of the need to kind of work together and to align where possible regulatory approaches. And this report does give us the kind of the understanding and the evidence base to continue that work going forward. What strikes me, and I'm going to adopt an optimistic tone here, what strikes me most from the report is that to a large extent there does exist a lot of overlaps and complementarities between particularly the OSB and the DSA. And I think there's more overlaps than there is divergences. For instance, both regimes put risk assessment at their core, focus on improving systems and processes within the regulated firms, and ultimately they give people like Irena and myself within the regulatory bodies a new suite of tools to help ensure effective enforcement, and also to help support companies who have to comply with what is quite complex new regulation. And indeed, that is something that fills me with a lot of hope for the future, because I am acutely aware that these are next generation approaches to regulation, and that we are trying to solve for problems which are to some extent a little bit unprecedented in the online space. And we've never really thought about doing things like risk assessments or algorithmic audits in the online space. And so now we're going to have to develop the new set of regulatory tools and the regulatory understanding to do that effectively. And that's where this sense of overlap becomes quite useful, because there is, I think, tremendous opportunity both within the UK and within the European Commission and across the EU member states to effectively play the role of setting what are going to be hopefully new global standards and norms for how we regulate the online space. And given that we are thinking about a lot of the same problems, and we are trying to solve for a lot of the same issues, that kind of sense of dialogue and capitalizing on that overlap is going to be very, very important and useful in the years to come. I'm also mindful, reading the report, that a lot of what we're talking about here is still to some extent hypothetical, as in we are looking at legislative texts that, at least in the EU case, are already adopted, and in the UK with the Online Safety Bill, we are moving towards royal assent and towards entering into force. But in many respects, we are thinking abstractly, and a lot of these things haven't actually been tested in the wild. And that is going to be critical in the next couple of years to actually see to what extent our hypotheses about where the various regimes overlap and diverge, how that actually plays out in practice. Because I look, for instance, we have just completed the first year in the UK as Ofcom of supervising video sharing platforms. So the UK transposed a version of the new AVMSD a couple of years ago, and we've just finished our first year of actually supervising the firms, the VSPs that are established in the UK. And that has been a tremendously informative experience, just in terms of, for us, understanding the new tools and capacities we need to oversee firms in this way, and also for the companies, many of whom are going to have to comply with similar regulation under the OSB and the DSA, for them to understand what this new kind of relationship with regulators looks like, and how they need to think about kind of systems and processes style approaches to enhancing online safety. So as various regulators around the table continue to go down this process and start to implement these new regimes, it's that sense of kind of collaboration and communication and understanding how things work in the wild, I think is going to be tremendously important, and ensure that for the people we serve and for the companies whom we regulate, that we achieve the best outcomes. So I think I'll stop there, because I know there's a lot more to discuss. But again, just want to put on record how useful this report is for us going forward, and the fact that there is so many people who are in the virtual room today suggests that many of the stakeholders think this work is incredibly important too. So thank you.
Thank you very much, Owen. Yeah, we're looking forward to seeing particularly the DSA now, how it works in the wild. The AVMSD gave us a taste, and now we're going to get to see what happens with the others. And we'll go now to Zoe Pellegrini from Mediaset, another one of our industry representatives who is essentially in the wild. Then I guess you are the wild that we are.
Thank you very much, Sally. I think it's less in the wild now with the new rules in place. And so just echoing the other panelists, to thank you for this interesting study, a very comprehensive overview of the different pieces of legislation and of their interplay. So that was very helpful to us as well. I'll just take it from the perspective of, a commercial broadcaster. So focusing very much on media pluralism and of how this has been addressed in the DSA and in the AVMSD. I think as a baseline, we see as a major difference between the AVMSD and the DSA, the fact that the AVMSD for audiovisual media service providers has taken a horizontal approach in addressing harms, while in the DSA, there is an incremental approach with these progressive due diligence obligations that apply to services according to their reach. So we see this major difference. We very much support this framework, the DSA framework that has been adopted by the European legislator, and especially the fact that this, as also Irene was saying, is a horizontal framework, but to which new sector-specific legislation can be, in a way, plugged in, as Commissioner Breton used to say. However, in a way, we still see some gaps in this DSA horizontal framework. For instance, the limited scope, of the Know Your Business Customer principle in Article 30, which only applies to marketplaces. We would have liked to have a wider scope to really reflect the principle that what is illegal offline should be legal online. Also, I think another point that we would raise is the fact that we still don't see the piracy of live streaming addressed in this horizontal framework. So we would very much, want sector-specific rules to really address this specific problem, and in a way also safeguards for publishers' content on very large online platforms are missing, and you have put this in your report. So these are really the bits that we see missing, and some of them could, however, be addressed in the in this proposal on the European Media Freedom Act. I'm talking especially in Article 17. So this new article of the European Media Freedom Act that would allow us, to at least be informed by very large online platforms before they remove our content. So we see this as a good start in the EMFA proposal. And also another point that would and another article that would that is actually supporting media pluralism in the EMFA and nicely complements the AVMSD is Article 19 on the right of customization of audiovisual media offers. So this article in a way keeps the AVMSD relevant and ensures that services of general interest, which are subject to very stringent rules to uphold cultural diversity, ensure news and information are properly distributed and offered to viewers. These services should continue to stay visible and easily accessible to viewers. But viewers should, however, have the right to customize all the other offers. So we see also this as a good angle to support a pluralistic and diverse media landscape in the European Union. So I think these were just the general points on media pluralism that we would like to raise from our perspective. And I thank you very much again for this, this insightful report and for the discussion. Thank you very much.
Okay, thank you, Zoe. We do have 2 questions waiting, and we have some more ones that we wanted to discuss. But first, I wanted to just react on the issue. We struggled quite a bit on this issue of one is a horizontal EU-wide piece of legislation. The online safety bill is a national approach to digital safety. Then we have the specific, sector-specific AVMSD and the kind of harm-specific TREG. And so we tried to have that sort of in the back of our mind as we were looking at these things. But I think, it touches quite a bit on this interactions now and implementations issue. And I think when we were thinking at the OSB, we could see that this is a, example of a national approach to kind of establishing illegality. So we have certain offenses that are now being created once the bill is passed. Such as the sharing of intimate images without prior consent, for instance. Not currently illegal, it will be illegal if the OSB is adopted as in. Different countries will be doing other things, perhaps, to establish things that are illegal. we have the EU level legislation. TREG was an example of EU legislation that dealt with specific criminality. Then we have the CSAM one in the works. We have anti-piracy, one of the concerns Zoe just raised. There are different ones that are addressing these specific things. And then, so I think there's some interesting things to look at now as to how does the DSA in particular then end up capturing all of that? How are those who are regulating and those who are complying with it deal with this about, you know, what is illegal and when, if there are any contradictions among member states as to what's illegal? I mean, I can think of some things that might be deemed to be illegal in some member states that are more conservative for various reasons that might possibly contradict EU level fundamental rights understandings, or might be different in other states. So then what are the mechanisms? So that was one thing that was raised for us. Michelle, I want to give you a chance also if you wanted to come back on any of the things that the speaker raised, and then we'll go on to some of the questions.
Yeah, thanks a lot, Sally. I mean, I don't want to take too much time, but thank you for all your comments. I think they're all valid. I think maybe it is a very theoretical exercise at this stage that we've done. I think Owen's right to highlight that. The pieces of legislation that we've looked at are all very, very recent and have hardly had a chance at all to be put into application. So for sure, you know, if we come back again in a couple of years' time, we'll be able to see, you know, if just the two issues that we've looked at, which is scope and services in scope and harms, are creating any problems. We'd have loved to go and look at the proper overlaps, you know, in practice, what does it mean, you know, if you're faced with this type of offence, you know, which regulation do you apply and how does it work out? I think that would be great, but it was just something we didn't do because it was probably too complicated. And then I think, you know, how future, I mean, the point about the codes of conduct that will help. I mean, yes, it's true. I think that's something that will certainly help, and will help to, you know, put more flesh on some of the rules. So that's good. And then I thought that how future-proof. I mean, I'd love to discuss that point that Matt raised about, you know, how future-proof are the pieces of legislation going to be, and we take metaverse, say, as an example, and see if the OSB definitions are going to be wider than the ones of the DSA. They're certainly less technical, I think, even if they're difficult to read. The definitions in the OSB are difficult to read. But maybe they are a bit less technical than the ones of the DSA. But that we can discuss that maybe during the discussion now.
Well, why don't we go ahead and deal with this issue of future proofing, so to speak? I mean, we raised the example of Mastodon. We have the metaverse was already, and we have a world of gaming that was identified kind of as a gap. How you know, are these tools able to deal with these things yet? You know, if we're looking at rather individual harms and content being the subject of certain pieces of legislation, does that translate into the metaverse? If we, what might need to be done, or how might these things be interpreted in order to make them applicable? Anyone want to jump in?
Maybe Matt, if you go into it, you seem to be interested.
Well, yeah, as I put it on the table to begin with, I think it would be fair and sporting if I took an attempt to answer the question. I think there are two parts of it. The first kind of question is, should we even be attempting to update the regulatory frameworks that we have now to accommodate technologies like the metaverse, or even ones, you know, that you mentioned are already existing on the market, like various types of, you know, interactive and virtual environments that you have already in enterprise and in gaming situations. And for me, one of the key criteria you would need to assess to make that determination is the extent to which that online space represents an open platform, a public space, if you like, or conversely, it represents a private communication channel between two or more users. And that's a really important distinction. And we shouldn't be, I think, too eager to lump in any type of technology, communications technology, into the scope of the DSA without making that fundamental determination. Is this essentially a public communication platform, or is it another way of a closed group of users communicating, albeit in a much more all-encompassing virtual environment? Once you get through that, then the question is how. And I think there are provisions that are inbuilt, both within actually the DSA, and we're not talking about it today, obviously, but the Digital Markets Act, the DMA, to essentially, you know, kind of expand the scope of the regulation over time, you know, through the process of drafting, implementing acts. But the question then is, would that be sufficient, actually? And does that represent due process with regards to what would be quite a fundamental change? Or should there be a kind of full cycle of regulation where the Commission, you know, takes a long run at this, they publish, you know, their communication, they consult on that, they have a full impact assessment, etc., etc. For such a sweeping change, actually, you would think that maybe a more fulsome kind of regulatory process would be appropriate. So I think those are the two questions. Firstly, should we? And secondly, how? And once you get through both of those, I think we are looking at another multi-year process. But I do think the DSA has a number of inbuilt advantages, and I think we can be hopeful that it's, you know, it's sitting on the shoulders of giants, in the sense that, of course, the e-commerce directive has proven to be extremely durable and future-proof, you know, in terms of, you know, something, a law, you know, lasting well past its expiry date almost, when it comes to the service providers which have entered the marketplace since it was introduced. So I think that there are some inbuilt advantages that we have with the regulatory framework that probably stand it in good stead. We're not going to have to overhaul the thing immediately, I guess is what I'm trying to say. But I can see the hands are popping up, so maybe there are reactions already.
We didn't think so either. Okay, so I'm going to turn to Owen and then Irene.
Thank you, Sally. I can give a short answer, and then I'll give a slightly longer answer to this question. The short answer is that when it comes to the metaverse, we're confident that, to the extent that online safety issues may emerge in that space going forward, that we have the tools to address them. Let's remember that many of the technologies upon which this is built, and many of the functionalities which we can expect within the metaverse, are analogous or similar, or simply replications of functionalities which we exist in kind of Web 2 or in other online spaces today. And so many of the kind of systems and processes and mitigations that firms will be expected to deploy in the metaverse are similar to ones which they will be deploying for other online services. At the same time, we're also quite keenly aware that there is some novel features to this space, things which are a little bit unprecedented. And so that's kind of why within Ofcom, we're already starting to do a lot of research, working with companies, with developers, with academics and other regulators, just to understand how this new space is emerging and whether or not specific kind of mitigations and novel ones are going to be required to address some of the online harms. The broader point I would make about the metaverse is that it poses a range of interconnected regulatory challenges. So there is obviously the online safety piece, which we are very much concerned with, and which we will be tracking quite closely. But there's also a range of issues around competition, like how do we ensure that the metaverse, that there are multiple metaverses for which consumers have choice in? How do we ensure that people's sensitive data is protected? How do we ensure that this new space is inclusive and ensures inclusivity of the most vulnerable users? And those are cross-cutting regulatory issues, and they're regulatory issues which regulators are going to need to cooperate with each other, both domestically and also internationally. And so to give an example of how we're trying to address that in the UK, some of you may be familiar with the Digital Regulators Cooperation Forum, the DRCF, which which brings together Ofcom, the CMA, the FCA, and the ICO. So all of the kind of regulators which deal with some piece of the online space. And we're actually using the metaverse as one of the case studies where we are trying to have a more joined up approach, because the regulatory issues are going to go beyond just the sum of their parts, and there may be overarching pieces. And so we hopefully in the next couple of years or so will have a lot of outputs on that that can inform the broader direction of travel in this regulatory space.
Thank you very much. We will look forward to that. And I think there's a wide recognition that these things are interlinked, hence the DSA and the DMA were proposed together. You know, this is all part of a package, and it has been interesting to follow these conversations happening across different kind of what had been separate regulatory spaces and are now not so longer separate. Irene, do you want to come back?
Yes, thank you. I wanted to come back and in a way a bit in line with also what Matt has said, because I was just traveling in time to July 2000, where the e-commerce directive was just published, and imagine some said, oh, and by the way, do social networks apply? Are they covered in scope? Search engines, are they in scope? Or live streaming services are in scope? Video sharing platforms, we did not have a popular one, but they came afterwards, and this did not stop the court to identify those services as hosting service or other types of services as another technical activity. So it proved that the e-commerce directive was already future-proof by then, and the DSA has not invented the wheel. So we have just taken those technical activities. We, in the recitals, the co-legislators have clarified which activities or which business models are supposed to be covered, but there is nothing new. So if a new business model arrives, a new animal comes into play, then I would go back to the basics. First, it is a service. It is an economic activity, yes, no. It is a technical activity that relates to one of these three groups, like conduits, caching, hosting, and then we will see the scope, whether it fits. Obviously, there will be a moment where something is beyond, but it's not the end of the world either. Because for the DSA, for instance, on the provisions on liability, it says explicitly which services and under which conditions they are protected from liability, but it does not mean that the space that is not covered is subject to liability. So maybe they are in a vacuum, in a gray zone, but it will be still for courts to determine whether they are there is a causality link with the harm that it can be caused. So I don't think that this discussion, because it could run eternally, does Mastodon is subject to the DSA, is Metaverse subject? This is something that will have to be elaborated on a case-by-case basis.
Okay, thank you very much. The e-commerce directive certainly has stood the test of time, and I think it shows the flexibility of those definitions that were there. Zoe, you wanted to come in?
Yes, just to add, I think I very much agree with Irene that we don't have to reinvent the wheel in a way. We have our basic principles, and indeed, I think the DSA has really supported having our basic principles online. So having ensure there is transparency, and also that we know how content is in a way distributed to users, how it is promoted. So I think these basic principles of just transparency and in a way accountability also about algorithms and services in general is something that can be applied to every service going forward in a way.
Thank you. One of the things that I think that is quite revolutionary here is the risk-based approach in the DSA and the online safety bill that Owen was mentioning. But I also want to pick up on the idea of functionalities, because in the online safety bill and the AVMSD and the TREG, we have quite a focus on content. And I think something the DSA brings to the table is this recognition that the very functionalities could be a source of harm, or the systems that they are using, even perhaps arguably the business models themselves, might be part of posing that risk. And that's something that that the DSA seems to introduce here, I think, in a quite interesting way. And I'm wondering now, if we're thinking about future proof, does that give us some, kind of flexibility, some ways of thinking about it that might enable courts to then say, yes, this is something that does have those systems, does have those functionalities that could pose risk, and therefore might help in determining some of this stuff in the future. I do also want to get to one question, so I'm going to go ahead and pose. We only have sort of 10 minutes, so I'm going to go. The one question was already answered, but we have a question about this kind of individuals and recourse. And one of the things that we identified was the distinction between the individual harms to individuals and harms to more collectives in these pieces. So do we what are the ways that this is going to work sort of in implementation, and is there a need to look at more sort of collective recourse in any of these instruments? So I'm going to throw out sort of my question. Michelle, did you have any more questions you wanted to throw out before we do closing comments?
No, I haven't got something immediate coming.
Okay, so we're going to just do sort of one more round, and we'll start if anyone has fine. Yeah,
I've just got one little question, and that was for Irena, and it was in relation to what Matt was saying about okay, it's we'll see what emerges, okay, in terms of new services. We'll analyze if they fall under the definitions or not. Matt was saying, well, what about, delegated acts, implementing acts? My understanding is that the Commission can only really adopt those in the areas that are specified in the DSA at the moment, and then you've got areas where you can produce guidance, right? What about under the, going back in time, like under the Regulatory Transparency Directive years ago, there was this big Commission guidance that came out on what was an information society service, and that helped tremendously to understand the scope of the definition, what was in scope, what was not in scope. And I remember I read that inside out. And I always thought those sorts of documents are incredibly useful as well to shed light on some of the notions. And I was wondering, Irena, if that's something that the Commission is still, could the Commission do that? Can it adopt a guidance on an area that's not mentioned in the DSA? So on definitions, say there's nothing mentioned, but could it?
Yes, I think the short answer is yes. Because it is not a delegated power, it is not an empowerment from the co-legislators, and the Commission guidances, notices, or however we call them, they only represent the views of the Commission. Yeah. So, for instance, if there are elements that are interpreted differently or in very differently ways in member states in order to ensure consistency or to guide courts, but again in a non-binding manner, they are not binding. This is just what the Commission understands that these provisions mean, or how they should be interpreted. But indeed, this is not something that is limited to those elements that are explicitly requested in the DSA. The DSA also does not impose any obligation on the Commission to issue guidance. All 5 instances are may provisions. Yeah. So indeed, the only point of caution is that in order to issue guidance, we will need to see first how the DSA is applied and interpreted to see whether there is actually a need to have some orientation.
Okay, thank you. And that's nice to hear. I think. Thank you.
I think it was clear there's going to be quite a feedback loop of trying things out and then seeing what's going on. Is that correct? Sure. So Irene, if there are any other closing comments that you would like to make, we would then start with you and we'll go through the speakers in the same order for some closing remarks or thoughts or final questions to throw out for future consideration.
Yeah, I have a final remark. It did not come across in the discussion or in the study, in the report. I think for me, the most definitive characteristic of the DSA is that it is based on procedures and not on content. It is not regulating content. Even if we have talked about the last hour only about content, it is only about the procedures. And that's why the DSA does not include a clear explanation of what is illegal and what's not. This is for other instruments or national laws to determine. But we want to have clear procedures, transparent procedures, and accountability on how content is moderated, be it illegal, be it against terms and conditions, or other types of harms which are not necessarily illegal, but can indeed be harmful. So I think this is the main line that distinguishes the DSA from the other instruments.
I think we might have been kind of assuming that understanding when we started out. But I think that the AVMSD also sort of takes this more procedural approach in its approach to VSPs, because it's looking at what they're held to account for is the appropriateness of the measures that they're taking in order to prevent harm from those certain kinds of content. And when we were talking about the distinction between content and stuff, it is about where the sources of harm are expected to be coming from. But yes, this is a very important element of the DSA. We are talking about procedural accountability essentially, and it is the processes. So thank you for raising that. We took it as a part of departure, so sorry we didn't start with that. Okay, so then we'll turn to Matt and then Owen and then Zoe.
Thank you, Sally. This has been a really stimulating discussion, actually. I think we've teed up a lot of future food for thought as well, which is always great. And I just wanted to pick up, actually, in closing on one of the remarks that you made and sort of skated over, but is really important, actually, when it comes to implementation of the DSA, which is the focus on the functionalities of the given service providers and making sure that the due diligence obligations are fairly targeted and proportionate to the actual functionalities of the service providers that we have. I mean, we did have to work, I think, very hard throughout the co-legislative process, dealing with amendments that were coming in, particularly from the European Parliament, to ensure that that principle was really maintained and that you didn't end up with some of the obligations being kind of just drawn across the board in a rather indiscriminate fashion, because we felt that would have been disproportionate. And I think there are two things to look out for maybe in the future, because we understand well, and I think it's been very evident in this discussion, that the kind of the pure technical intermediaries and the more classic hosting services we understand. Building on top of that, user-generated content platforms we understand. But there are a few additional obligations, due diligence obligations, which are built into the DSA, which will be, I think, kind of slow burners, particularly around, for example, algorithmic transparency and ranking, the reference that we have to dark patterns, I think, which is under Article 25 now of the final DSA, and this notion that, a certain subset of the kind of, let's call them online intermediaries, have gone beyond their traditional neutral hosting functionality and are now doing more and more things to actively promote and recommend forms of content to end users, which does trigger new responsibilities which didn't exist in the past. I think that will be the kind of, I guess, the lodestar for implementation of the DSA. And then maybe just a final appeal for coordination between and across regulatory authorities. I think we mentioned the different sectoral regulators, but of course this has been a discussion which has been largely cast in view of the UK and the EU regulatory processes. As a company, as I say, that straddles both markets, it's important for us that we do have as much alignment and consistency as possible in enforcing these parallel regulatory frameworks to ensure that there aren't gaps and too many inconsistencies which we need to manage. So thank you. I'll stop there.
Thank you, Matt. Owen.
Thank you, Sally. Yes, so Irene, just in her closing remarks, mentioned the fact that the DSA is based on procedures and not about content, and indeed that is similar for us in the UK with the OSB. We don't use the term procedures as much, but we really talk about the kind of systems and processes based approach. And so now the next couple of years on our side is going to be focused on, well, trying to understand how these systems and processes that firms have in place, how they need to be attuned to address the various regulatory duties and to minimize harm. And that is going to be a challenging task requiring a lot of effort on our side, but also a lot of effort on the company side, because they ultimately are the ones who have to translate these regulatory duties into compliance measures. So that is going to be an ongoing piece of work, and it's going to require a lot of effort from all parties. But obviously, I'm aware that thinking about what these measures look like in practice, what good looks like, and how we do measurement is going to be the same problem that regulators across Europe and across the world face. And so for us now, while trying to kind of keep our own backyard in order, what we're also trying to think about is how we can, like, to the point that was just made, like how we can kind of align internationally and kind of ensure that we're coordinating where possible. The good thing is that in the online safety bill, Ofcom will have new powers to coordinate more internationally, and we will have new, what we call, information sharing gateways that hopefully, as we are learning more about our regulatory approach and as we are gathering information from enforcement actions, that we will be able to share out with our partners in Europe and beyond. So that will be hopefully a new and important role that we can play. And then secondly, thinking yet in a more global best practice sense. So just this week, we launched together with regulators from Australia, Fiji, and Ireland, the Global Online Safety Regulators Network. This will hopefully become a forum where we can start to coordinate more internationally and share best practices. And we will, of course, as time goes on, be hopefully expanding that network further and welcoming on board colleagues from the European Union and beyond. But I will stop there, and yes, thank you again for the opportunity to be here, and look forward to getting into even more detail into the report.
Thank you. Okay, thank you. So, do you have any?
No, I think it will, yes, it will be interesting to see, how this framework actually, how the implementation of this new framework actually plays out. So, and how the sector-specific legislations will interplay with the DSA. On this, I think also the enforcement, this double enforcement that will be carried out by the European Commission for VLOPs and blows, and how digital services coordinators will enforce for the other intermediaries and online platforms. This parallel enforcement will be interesting to see, and so yes, I think let's see how it plays out in the future. Thank you.
Thank you. A lot of things that we're thinking interesting to see, and we're kind of saying this with sort of crossed fingers in itself. But I think there's some really interesting tools that have been given, haven't they, to the regulators now to do this. Michelle, do you want to make any final remarks? I think we've heard quite a lot of things that would open up new directions for next projects, perhaps.
Yes, no, let's not talk about that. But yes, certainly, I mean, all this comparison as well between, what is it exactly that is expected from the services in scope, on comparison on the processes and systems. And I've got an aeroplane going up on top of my house now. But no, I think as well, I mean, for me, what I see a lot is, I talk a lot to regulators and ministries and operators as well, and everybody's sort of saying, it's enforcement's going to be the key on this. So I think the more cooperation, the more guidance from the Commission, and the better it'll be, basically. Cooperation within the countries, of course, because there's this digital service coordinators that need to be set up, and then the coordination between different block regions of the world. I mean, obviously, we're all looking at the same things. and trying to regulate the same services vis-a-vis the same sorts of harms. Not, I mean, it's not, everything's not the same as you've seen in the report, but basically, so yeah, more cooperation and guidance, I would say. And good luck.
Yes. Okay. Well, thank you very much to all of our speakers. We do have some more events coming up in this space at SER. And Michelle and I have, as she just mentioned, taken some things forward to be thinking about. We definitely see this as a kind of starting point. And of course, there are more, specific content related pieces of legislation coming. And we still don't know exactly what the online safety bill is going to look like. So we will be paying attention to that. And there are also interesting developments going on in Canada and in lots of other countries around the world. So we hope to be coming back to you with another event in the future. I think we managed to address the questions that were raised. If you have any future ones, then feel free to get in touch with us. You can contact us through the details that are available in the report. And I'd like to just thank the SER team for supporting us in the headquarters for the event. And once again, thank all of our guests for their excellent input and very useful feedback on our report. And I look forward to seeing you again at another discussion in the future.
Bye-bye. Thank you very much.
Bye.
Thank you.
Bye.